Okay, we'll go on the record now. This is Franken Mutual Insurance versus Schneider, case number 2214030. And Mr. Schumacher, if you can unmute yourself, please.
I think I'm unmuted, am I not?
Oh, I guess you are. My computer's saying you are, but I can hear you, so that's a good thing. Okay. All right, and then we have Mr. Ifnar also present. This is set for a scheduling conference in this case today, status conference. On behalf of plaintiff, Mr. Ifnar, can you tell me where things are at and what you'd like to do in terms of scheduling going forward?
Sure, Judge. I had a chance briefly to talk with opposing counsel this morning. I think he is going to represent to you that he would like to file a motion to withdraw. I'll let him speak to that issue. Last time we were here, which was some 90 days or so, the adjournment was granted because the defendant Schneider was going to file bankruptcy. He hasn't done that yet. So my position is my plan is to go forward and file a motion. This was pretty straightforward factually. Rear end accident, no insurance. So I'll probably plan to file a dispositive motion on the issue, request a judgment. If he files bankruptcy, so be it. But we waited 90 days, nothing's happened. So my plan is to go forward.
Okay, is there a particular time that you'd like to request to get that motion filed?
Well, because it's a dispositive motion, Judge, I've got to give at least 21 days notice. So my guess is I'll file it in January or I'll file it in December and get it heard sometime in January. I don't know what your schedule is like, but maybe later January will be a hearing date, and that'll prompt me to get off and get it filed.
Okay, all right, very good. Thank you. Mr. Schumacher?
Well, Your Honor, my client has not been responsive, and I finally reached him this morning. He doesn't have the money for the filing fee yet. He's got all but $300. He's hoping to get that for Christmas and file bankruptcy. But because he hasn't been very communicative, it's hard for me to predict whether anything was going to happen that he tells me. So I'm pretty sure he'll stip to let me withdraw. And that's my intent at this point, is to withdraw, although I might discuss it with him a little bit further. My inclination would be to have the motion filed in January, thereby giving him some time so that we can see if he does file bankruptcy by early January. And of course, if he doesn't, then that's the way it goes.
Okay. All right. So for purposes of the status conference order for today, Mr. Hiffner, I'll just indicate plaintiff to have 60 days to file dispositive motions. That'll give you a little bit of extra time if you encounter any issues due to the holidays or whatever for that. And then I will set this as a status conference as a control date at about 90 days in case there, for some reason, there aren't any motions filed or nothing happens. We'll have that out there as a control date to check in. Mr. Schumacher, the court will look for a stipulation in order withdrawing as counsel. If, again, if your client files for bankruptcy prior to Mr. Hiffner getting his dispositive motion heard, then if counsel can just file a stay based on the bankruptcy proceedings, then that'll take care of that part of it as well. So I think we have all our bases covered there with a way to proceed here one way or the other. Mr. Hiffner, anything else that you wanted to address for the record today?
Yeah, if you could, Judge, could I get a date cleared with the court sometime in January, maybe middle to late January for a hearing date? That'll basically put this thing out at least 45 days.
I can't schedule that from the bench. I don't have my calendar and docket. So, okay. But if you call We're at my office. She'll be able to get a date for you and a time.
Very good. I will do that.
Okay, thanks. Mr. Schumacher, anything else I can address for your side?
No, Your Honor, thank you.
Will you be sending
Okay.
Judge any sort of summary of the status conference today, or do we just note it ourselves?
Yes, there will be a status conference order that goes out with what we discussed today.
Perfect. Very good. Have a great afternoon. Be safe.
All right, thank you, you too. Excuse me, all parties are free to disconnect.
Thank you.
Thank you.
All right, do you want to go on the record in Clark versus Clark? That's case number 2314292. That was set for entry of a default judgment of divorce today by Zoom. Neither party has appeared. We did get a message from Mr. Clark indicating that he had, well, Mr. Clark was to appear in person, I'm sorry. But regardless, we had got a message from Mr. Clark that he's had some various difficulties in making it to the court today. Ms. Clark has not appeared by Zoom. And so we'll need to reset this for another hearing in about 30 days. That'll be an in-person hearing. And we'll specify that the court will set this for a hearing and notify the parties, notify both parties. And it will be, again, an in-person hearing. Okay, that's it.
Afternoon.
Okay, Mr. Hulst, are you able to hear me okay?
Yes, I am, Your Honor. Can you hear me?
I can, thank you. All right, hold on one second. Whoever's there's somebody on a fire tablet. Can you unmute, please? Ma'am, can you tell me your name, please?
Yes, my name is Jeanette Ayton. I am legal guardian and conservator for Judith Martin.
Okay, very good. And the person on Christie's iPhone, can you tell me your name? Can you unmute and tell me your name, please?
Christy Clark.
Okay, Miss Clark, your hearing was set back at 1:30. Yeah, so the court had to reschedule because neither you weren't there at 1:30 and neither was Mr. Clark. So
I've been on here, sir, since 12:30.
well, you
I
didn't
know
show
that
up in my
Roger.
Zoom. You weren't in the Zoom waiting room here in my courtroom.
Okay. Yes, sir.
So the court's going to reset it for a different date. If you have questions, you can contact the clerk's office and they'll be able to get you the next date.
Okay, thank you.
Thank you. Okay, Mr. Hulse, were you ready to proceed on your case today?
Yes, Your Honor. I was just in contact with a memory care unit. My client is at a Kalkaska, the hospital nursing home type environment right now. We do have the legal guardian with us, so I think we can potentially proceed without her. I have someone from my office talking with Kalkaska right now. They're having a little bit of difficulty getting on. Let me just send them the Zoom ID number they're looking for, apparently. 1 second, please. All right. My office should be sending that. Yes, Your Honor. Basically, what we have here is my client filed for divorce in April of 2023. Since that time, she has been deemed legally incapacitated. At the time that we filed for divorce, she had legal capacity, but that has obviously changed, which led to the delays that we have now. The defendant, Bob Martin, has not filed an answer in this matter. He's been served with all of the relevant documents. The time period required before entry of a divorce has been met, and the statutory grounds for divorce have been met in this case. So we would request for entry of a default. We have provided a copy to the court of our proposed judgment of divorce, and I'd be happy to address any questions that the court may have with regard to the equitable division of the assets in this case.
All right, so I did have a chance to review your filing, and I agree that the default is appropriate in this case. I think the file reflects that Mr. Martin was properly served with the summons and complaint that he didn't answer, and the default was properly entered. He was provided with notice of the date and time of today's hearing, which was 2 o'clock. We're now past that point, and he's not appeared to contest the divorce. I did review the proposed judgment, and the court does find that it's generally equitable. So I guess, and I didn't realize that Ms. Martin was incapacitated, so I didn't really look at this issue prior to the hearing today. So Mr. Hulst, my main concern is, regardless of all of those other things, the court is required to take sworn testimony to establish the statutory grounds, and there may be some authority for doing it another way, but not that just sitting here right now.
Yes, Your Honor. I did hear back from the nursing home. They said that Judith would be on shortly. Based on my conversations with the guardian, Judith, in terms of her cognitive abilities, it does vary from day to day. The last time that the guardian visited, Judith was having some significant issues. I believe that, guardians have the authority under Michigan law to basically approve of a divorce, and it's our position that Miss Ayton has the ability to establish the proofs on the record for the court that would allow the court to enter the judgment of divorce, as well as some of the surrounding circumstances that the court could consider, such as the personal protection order that was entered by Judge Boudet in Kalkaska County, prohibiting Mr. Martin from having contact with Judith.
Okay, and I'm not disputing that. I just don't know what that authority is, and I appreciate that you're representing that there is the authority that would allow for that. But I think it'd be in the interest of all parties for us to put that authority on the record, so that if there's any questions later on, I don't like to just go on assuming I have the authority to do something because somebody tells me I do. I like to have something to cite to for the record so that I can rely on it. And as I said, I wasn't aware this was going to be an issue. Otherwise, I would have looked at this myself prior to the hearing today.
Yes, Your Honor. In terms of,
and frankly, in 11 years, I've never had a divorce where one of the parties was incapacitated and the other party was defaulted, where we had nobody who could put on the statutory proofs. So this is an issue of first impression for me.
Yes, Your Honor. Issue of first impression for me as well. I would just cite to the general legal authority of a guardian under Michigan statutes, and let me pull up the authorities that the guardian has. All right, MCL 700.5314 contains the powers of a guardian. So when we look at the authority of a guardian, the powers and duties, essentially, the guardian is put in place and is responsible for the ward's care, custody, and control. And in such a position, they're going to have the authority, and based on conversations that Ms. Ayton has had with the ward, she would have sufficient knowledge to establish on the record, together with the public documents that would establish the date of marriage and location of marriage. And then I would ask that the court consider the public record of the PPO as evidence that there has been a breakdown of the marriage, to the extent that the bonds of matrimony have been broken and there's no reasonable likelihood of reconciliation.
Okay, is it Ayton?
Yes.
Okay, can you tell me the scope of the guardianship that you have? Is it a full guardianship?
I have full guardianship and full conservatorship from Kalkaska County Probate Court on Judith Martin.
Okay, thank you. All right, so Mr. Hulse, what I'm going to do, I'm going to just take a short break. I'm going to look at the statute that you cited, because again, I don't want to just assume that I have the authority to proceed today. So we're going to take a short recess. I'm just going to ask everybody to stay connected, and I'll be back on the record in just a couple minutes.
Yes, Your Honor. Thank you.
Okay, Mr. Hulst, before we get back to your case, I've got one other matter I need to take care of here in the courtroom. So if you could just remain on hold there, please.
Understood, Your Honor.
Thank you. Okay, ladies and gentlemen, thank you for being here today. You're here because you were summoned for jury duty back on October 17th of this year, and you failed to appear for that jury duty. So we asked you to appear today. And the purpose of having you appear today, number one, is to just let you know that jury duty is an important duty. It's really an ancient tradition. It's part of our heritage, and it's crucial to our system of self-government. And the court can't operate without a jury. When a person's accused of a crime, and for as many knocks as our system gets, when a person is accused of a crime, that's not enough. The government has to prove beyond a reasonable doubt to 12 of that person's fellow citizens that they are actually guilty of the crime. And so the jury really plays an important part in our system of justice. And so if folks don't show up for jury duty, number one, the person who's accused of a crime, it inhibits their ability to get a fair trial. And number two, it inhibits the court's ability to function and provide for a system of justice. So it really is an important duty, and it's not something that is voluntary. It's something that citizens are required to perform. And it's so serious that if you fail to appear for jury duty, the court can impose penalties for that can include fines or even jail time. That's not something that I want to do as a judge, certainly, and I'm not going to impose any fines or certainly no jail time here today. I think you having to come into court and listen to my little lecture here is probably sanction enough and enough to hopefully impose upon you that it is an important duty and that you do need to appear for it when you're summoned. Sometimes people have reasons why they can't appear, work, illness, travel, those types of things. If you do get a summons and you can't appear for one of those reasons, just call the clerk's office and let us know, and we can excuse you ahead of time. And that way we know you wanted to appear, but you couldn't for a valid reason. And then we don't make you come in afterwards like this. So again, we're not going to impose any penalties, but hopefully in the future, if you get that summons, you'll either appear or again, call ahead and then let us know why you couldn't. Does anybody have any questions about that at all? No? Okay. Thank you very much for being here. We appreciate your time, and enjoy the rest of your day. Thank you. Okay, Mr. Hulst, are you able to hear me? All right, we're back on the record in Martin versus Martin, and I did have a chance to take a look real quick, and I noticed, Mr. Hulst, I see now that I've returned in the chat, I'm citing the exact case that I found here just a couple minutes ago, which is Houghton versus Keller, which holds that under the court rules 2.201E, MCR 2.201E, that guardian or conservator does have the ability to proceed specifically in a divorce action on behalf of their ward. So I find that there is adequate authority to proceed. So did you want me to put Ms. Ayton under oath so that you can establish the statutory grounds?
Yes, Your Honor.
Okay, Ms. Ayton, raise your hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and Mr. Hulst, please proceed.
Ms. Ayton, how do you know Judith Martin?
I was asked by the assisted living if I would be interested in being her public guardian. So I came and talked to Judith. At that point, she had a power of attorney who was not meeting Judy's needs to what Judy felt was the best interest of Judy. And so I went and visited with her. And just a little backstory, I worked with her many years ago by a prior name she had. She was the administrator of Meadowbrook Medical Facility. And so I agreed to become her public guardian. And then I can grab the date here, but then I was issued through Kalkaska County Probate Court that Judy did need a guardian and conservator due to her incapacitated state that she is in now.
Okay, and you are currently still in that role as legal guardian for Judith?
Yes.
Okay, and are you familiar with Judith and her desire to get a divorce?
Yes. Even though, I mean, Judy is, her dementia has been increasing over the months, but when you still talk about, she's always afraid that Robert's going to get, and we keep on assuring her that Robert can't come into the home that she lives in. And she says, you know, I don't want Robert. I don't want him to have my house. I don't want him to be with them. And she still, even though she has dementia, she'll go over and over again those things that she knows from rote memory that she does not want.
Do you know when Mr. and Mrs. Martin got married?
I do not know. I was looking in the records real fast when you stated that. I do not know that information.
Okay. And the marriage license and the complaint for divorce list December 31, 1999, and that they were married in Grand Traverse County, Michigan. At the time that Judith filed her complaint for divorce in April of 2023, had she lived in the state of Michigan for 180 days and in Kalkaska County for at least 10 days?
I did not become her guardian until October, but from what Judith has said to me, that she's lived here for many, many, many years.
And are you familiar with the location of Judith's residence prior to her going into Kalkaska?
Yes, I am. She lives at, or her home is in Kalkaska County. It's on Sharon Road. Give me the address. It's on Sharon Road in Kalkaska County.
And have you had the chance to look at the complaint for divorce?
Yes.
And based on your knowledge and conversations with Judith, are the allegations in the complaint for divorce true?
Of course, according to Judith, yes. And like I say, she repeats them.
And based on your interactions with Judith, do those allegations remain true today?
Yes.
And do you believe, based on your interactions with Judith and knowledge of the situation, that there's been a breakdown in the marriage relationship such that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Is Judith currently pregnant?
No.
Does Judith have any minor children with the defendant?
No, she has no children with the defendant.
And are you asking that this court grant an absolute judgment of divorce in this case?
Yes.
Your Honor, I believe based on Ms. Aiton's testimony as guardian that the statutory grounds for divorce have been met.
All right, having heard the testimony, I agree the statutory grounds for divorce have been met by the testimony of the guardian and conservator. The court has reviewed the proposed judgment as I indicated and finds it to be generally equitable, as well as all the other grounds for default having been met as I already indicated. So the court has signed the proposed judgment as presented by counsel. And Mr. Halstead will be available here at the clerk's office in Kalkaska. Is there anything else that we can address for the record today?
Nothing further, Your Honor. Thank you.
Okay, thank you. That's all for today. And all parties in this case are free to disconnect at this time. All right, next hearing is at 2:45. We'll be in recess until that time. Okay, ma'am, can you tell me your name, please?
Sarah Andrews.
Sarah Rose, okay. And sir, tell me your name, please.
Tig Rose.
Okay, I've got one case I need to address before yours, so I'm just gonna put you both on hold for just a minute, and then we'll take your case.
Okay.
Okay.
Okay, we're on the record in O'Donnell versus O'Donnell. And this is case number 2314223. The record should reflect that Mr. O'Donnell is present here in the courtroom today. And Mr. O'Donnell, you're here for a default judgment of divorce, is that correct?
Yes, Your Honor.
Okay. And is that how you wanted to proceed today?
Yes, I do.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, thank you. You can be seated. Okay. For the record, Mr. O'Donnell filed a complaint for divorce in this case, and Ms. O'Donnell was properly served with that complaint. She did not file an answer, so she was defaulted. And then this was set for hearing last month. We had some connection problems, so the court set it for hearing today in person. And Mr. O'Donnell, first of all, it's my understanding that you did provide Miss O'Donnell with notice that this hearing was happening today. Is that correct?
Yeah, that's correct.
And you told her the date and time.
Yes, yeah.
Oh, and that was 2:45. It's now 2:49, and Miss O'Donnell has not appeared in court today, nor has she signed in. And the court notes that she also did not appear for the hearing last month either. So, Mr. O'Donnell, I'm going to go through some questions with you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law, okay?
Okay.
You filed a complaint for divorce in this case, and you signed that complaint. Is that true?
It's true.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
It's true, yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes, that's true.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Correct, yes.
Does that remain true today?
Yeah, yes.
Are there any children who are under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
And to your knowledge, is Miss O'Donnell currently pregnant?
No.
All right. And with your documents, you submitted a property settlement and division document that lists the assets and debts and who's going to be responsible for what debts and who's going to get what property. Is that correct?
Correct, sir.
And Miss O'Donnell signed that document along with yourself. Is that correct?
Yes, we had it notarized at our my bank.
Okay, and are you asking the court to grant a divorce on the terms listed within that judgment or settlement agreement, rather?
Yes, if it's possible, both. There was a vehicle. There's a Toyota. It's a small Toyota car. It's not worth a lot or whatever, but in the divorce settlement, as far as property goes, we agreed that she would use it. But since then, she hasn't kept up on any of the bills I've provided her through the last 6 months since filing with cell phone, auto insurance, a number of other issues. And if it would be permissible by the court, the vehicle is titled and registered in my name, and I'd like to keep it for the amount of expenditures that I've carried her since the last 6 months since our legal split.
Okay, is that the white 2009 Toyota Corolla sedan?
Yeah, correct. Yeah.
Okay, so you're indicating that you want this to reflect that you will get possession of that?
Yeah, keep possession. Yes.
Okay. Okay. All right. Other than that, you're asking the court to enter the judgment based on this document that you submitted?
Correct. I also provided, I don't know if this is the right time.
Go ahead.
Stipulated a motion or please asking that that would be adopted and also a possibility to be granted spousal support. I took a early withdrawal for a primary purchase of a primary home a couple of years back. It was over $31,000 to purchase a home in Gaylord next to my work. I work for the highway department in Gaylord. And when I went to go close on the house for our family, she debited that money out of our account and has, I believe, been hiding it in Bitcoin. She says she's been scammed. Our institution the bank did an investigation, and there's like a summary here, and it stated that with the total charges of $33,576.02, they refunded my account from these debits, and they, under the premise that those charges were fraudulent against our account. Well, it came to find out the second time that I went to go close on this house that money was missing, like within hours of going to close. So I called the bank and I'm like freaking out because like this is a high stress thing for me. And it turns out that after her debit card was canceled off of the account and so forth, she was going in person and withdrawing these sums of money throughout the day, every couple hours, going in, pulling that money out. So then the bank provided me, or they called me about a week or two later, and they're like, hey, look, we put $30,000 in your account and Judy's taking it. What do you have to say about that? And I worked with the loss prevention services and asked them if there was anything that we could do, because she's got 2 boys from a previous marriage. I have 3 girls, and I'm trying to make a family out of this program. They extended an unsecured loan to both her and I. I signed it under duress, believing that she would be convicted of a crime for defrauding the bank that money. And because of it, the last 2 years now, from the date of our Zoom meeting that was scheduled previously, that was like 2 years to the date. I tried to encourage her to do the right thing and pay it back and try to make this right. And she really has made little to no effort to do that. Matter of fact, last week, over $375 was pulled from my account to pay this loan or rearages or whatever that it's behind, due to her lack of care to make this right. And like, I'm not good with Zoom, and I don't have any money to hire an attorney or a private investigator to be able to figure out if she's hiding this money in Bitcoin, either in the boy's name or in her name or her parents' name. But I really don't know what else to do.
So that sounds like a really complicated situation to me. And before I could do anything about that, I would need a lot more than just you coming in and telling me this. I mean, I would need a lot of documentation for the court to be able to take any kind of action on that. So there really is, I mean, I have no idea what's really going on in that situation based on this conversation. So that's not, I mean, you're talking about police, you're talking about banks, you're talking about loans that you're saying you signed under duress. There's probably a lot of paperwork involved in there that the court would have to see before I could determine what, if anything, you would be entitled to versus what she's entitled to and so forth. So what you have in this is one thing. You guys have laid it out, you both signed it. So I can enter a judgment of divorce based on this settlement. If you want to get into that, then I think, number one, I think you're probably going to need an attorney, because you're telling me you don't know how to put all that together.
Well, I mean, if I may,
Yeah,
the Michigan court rule for Form 11 for subpoenaing documentation or whatever, I mean, I could submit that all day long, but if she doesn't respond to it or take it seriously, like what other recourse do I or the court have?
I don't know. I can't give you legal advice. I'm the judge in the case, so I'm the one who would have to make decisions. So I can't tell you what to do or what not to do. And that's why I'm saying I think if you want to look into that situation, you may need a lawyer.
Well, I have no money, and Friday I have to go to front of the court because my first ex-wife is trying to increase child support on me, so I don't know what to do.
I don't either.
I don't know what to say next.
I don't either. Do you want to proceed with the divorce today based on what you have presented to the court?
Yeah, I don't see there being any more way. There's no, I don't have any way to produce anything without more money, and that's just the one thing I'm out.
Okay, so you're asking the court to enter the judgment of divorce based on the property settlement that you provided today?
Yes, sir.
Oh. So the court finds that the statutory grounds for divorce have been met by the testimony of Mr. O'Donnell. So the court will sign that judgment with today's date. And did you want to get a copy of this for your records before you leave today?
Okay.
Can you get that? Okay. All right. So if you just want to go, once we end with court now, if you want to go over to the clerk's office, they can get a copy of this for you. All right. That's all for today. Thank you. Okay, Mr. and Ms. Rose, if I could have you both unmute, please. Rose versus Rose. This is case number 2314250. Both parties at Zoom. This is set for a pretrial hearing in a divorce case. And Mr. Rose, you're the filing party. Are there any issues regarding the division of any assets or debts of the marriage, or have you been able to divide things up with Miss Rose?
We're good. Everything is good.
Okay, Miss Rose, would you agree with that?
Yes, Your Honor. Sorry, yes, Your Honor.
Okay. So what I can do is we could set this for a final hearing to finalize the divorce. Mr. Rose, there's one final form that you need to fill out. You can get this form online, or we have copies here at the clerk's office. That form is called a judgment of divorce, and that's the document that finalizes the divorce. If you can get that form and fill that out and submit that to the court, I will set this for another hearing. At that hearing, I'll need to take some brief testimony from both of you to establish the grounds for divorce. Then we can find that hearing.
Okay.
Mr. Rose, did you have any questions about that?
No.
Rose, do you have any questions?
No, man. No, sir. I'm good.
Okay, so the court will send out a notice of that next hearing by the mail. It'll be in about 30 days. Again, Mr. Rose, it's really important that you submit that judgment of divorce prior to that hearing so that we can finalize things on that date. And that's all I have for today. You're both free to disconnect at this time.
All right. Thank you.
All right. Tap the screen and leave.
Oh, thank you.
Yep.
Next hearing is set for 3:45, so we'll be in recess until then.
Is that
Okay,
you?
council, we'll go on the record in Graziano versus Two Spokes. This is case number 23-14241. And if I could just have council put your appearances on, please.
Sure, Your Honor. Good afternoon, Robert Wims for Giro's Plumbing and Heating, and hello to all, and particularly to Munib, who I've talked to, but I've never seen. Hi, Munib.
Good morning, Your Honor. Attorney Munib Ahmad on behalf of defendants, Two Spokes, and good afternoon, Mr. Williams. It's a pleasure to see you and finally put a face to the name and the voice.
You bet.
All right, counsel, I have Mr. Light also listed as counsel for the bank. Have either of you talked to him? I don't see him joining in.
I have not, Your Honor.
I have not, Your Honor.
But he's been included, I know, in some of our discovery things, I'm pretty sure. And for what it's worth, there's also a third-party defendant, another contractor, Jensen Schwab, who I believe, although they haven't filed an appearance yet, I believe Mr. Grogan, John Grogan, attorney here in Traverse, will be representing. So I know he's aware that there was something today, but I don't know if he's been formally retained, all that stuff. But I expect him to be joining us, at least as a participant here in the next couple of weeks.
Okay. All right. Well, I did have this set for a pretrial scheduling conference. Given that Mr. Light isn't here, given that we may have another defendant joining in. I don't know, Mr. Wims, what are your thoughts? Do you want to go forward with setting some dates today, or should we set this for at least a time when we have the third-party defendant counsel in?
Seem, Your Honor, judicial resources, especially since we can Zoom it, with Your Honor's permission, I think we probably do better to have all the participants in the rodeo to do that.
Yes, and Your Honor. Yeah, no, I don't object to that. And just to let you know, brother counsel and I have been working together already on discovery stuff. He's sent me his disclosures and his interrogatory request for reduction. I am in the process of sending over my disclosures, discovery requests, exchanging documents. We've had some discussions about possible resolution in this matter, and I'm awaiting some correspondence from Mr. Wims and trying to talk to my clients, see what we can do. So we've been meaningfully working together to try and expeditiously help you get this off your docket or slim out the parties.
I would concur in all that, Your Honor. We have been working at it. So
that sounds great. I love hearing that. So thank you.
No guarantees, of course.
No, believe me, I'm not, not in a manner of speaking, prejudging anything here. We'll see how things come out, but it sounds like you're off to a good start. So let's the court will reset this for another Zoom scheduling conference, and I'm going to set that for 60 days out, just to make sure that we're ready to go at that point rather than just 30 days. Sure. And we'll go from there at that point. Mr. Wims, anything else I can address for your side on the record today?
No, I appreciate it, Your Honor. And for what it's worth, what I will do as a courtesy, since both the two lawyers not included are, obviously colleagues, people known to me, I will email them and tell them heads up on that. And like I said, I expect Mr. Grogan to be filing an appearance any day now, and away we go.
Thank you. Mr. Ahmad, anything further from your side?
No, Your Honor. Thank you very much.
Okay, thank you. That's all for today. Both counsel are free to disconnect at this time.
You bet.
All right.
Take care.
All right. Thanks. We'll be in touch, Bob. Thanks.
All right. Yeah, I wrote that letter. Gonna get out in the mail.
I got you. Just email it to me. We can agree to email. You don't have to put it in the snail mail, waste your money. Just email it. It's fine.
You bet you.
All right. Thanks.
Bye all.